Welcome back again to my channel. Before watching this video, don't forget to like, comment, and subscribe. Now, let's start this video. The equation of the justice for fishermen, the urgency to protect fishermen and marine reserves in Indonesia, Part 3. The overlapping authority of law enforcement and judicial processes is one of the problems in implementing the fisheries law. Several legal issues that affect the effectiveness of the implementation of supervision and law enforcement, among others, are related to the overlap of authority between law enforcement agencies, drafting of regulations that do not pay attention to aspects of harmonization, obscure or vague norming, have not fully adopted the principle of cooperation responsibility. Formulation of criminal provisions that are not in line with the principle of the information of good laws and regulation, as well as the existence of self-regulation carried out by the judiciary, it is often counterproductive and creates new problems. The enforcement of maritime regime, the difficulties inside. Law was born from international customary sources. This international custom was born from the same action and carried out continuously on the basis of the same needs at sea. International customs are also common habits that are accepted as law. We warn that international custom as a sort of law do not exist as a sort of laws is closely related to international treaties. This relationship is a reciprocal relationship. International agreements are agreements that are held between members of the community of nations and aim to have certain legal consequences. Legal resources of sea law were the result of the 1952 UN Conference in Geneva. The conference, which was held from February 24 to April 27, 1958, was called the UN Conference 1 on the Law of the Sea, successfully agreeing on four conventions as laws. First, Convention on the Territorial Sea and the Contiguous Zone entered into force on September 10, 1964. Second, Convention on the High Seas came into force on 30 September 1962. Third, Convention on Fishing and Conservation of the Living Resources of the High Seas, Convention on Fisheries and Protection of Open Sea Biological Resources entered into force on March 20, 1966. Fourth, Convention on the Continental Shelf came into force on June 10, 1964. In the regions, there are sea areas which must be regulated with a different use. This part are the exclusive economic zone, the territorial sea, and other parts. The exclusive economic zone is a new arrangement established by UN Clause 1982. Long before the birth of this regulation, the outer boundary of the territorial sea was considered as the boundary between the part of the sea toward the land where the full sovereignty of the coastal state applies, and the part of the sea outward from the boundary where the freedom applies in the high seas. The arrangement of the exclusive economic zone can be considered as the result of a revolution that has changed in such a way the arrangement of the sea. In general, it can be defined what is meant by the exclusive economic zone, namely the part of the water or sea located outside of and bordering a territorial sea as wide as 200 nautical miles measured from the baseline where the width of the territorial sea is measured. The width of the exclusive economic zone for each coastal country is 200 miles as affirmed in Article 77. In Article 57 of UN Clause 1982, which reads, "The exclusive economic zone shall not extend beyond 200 nautical miles from the baseline from the breadth of territorial sea is measured, may exceed 200 nautical miles from the baseline from which the territorial sea with its width is measured." Article 55 of UN Clause 1982 confirms that the exclusive economic zone as waters or sea located outside and adjacent to the territorial sea, subject to the special legal regime stipulated in this chapter, is based on where the rights and jurisdiction of coastal states, the rights as well as other national freedoms are governed by the relevant provisions of this convention. This particular legal regime appears in the specificity of the law applicable of the exclusive economic zone as an integration which includes sovereign rights, jurisdiction and obligation of coastal state, the right and freedoms of other countries, freedom of the high seas, and the rule of international law as specified in the convention. The provisions of Article 71 of the Fisheries Law were later amended in Law Number 45 of 2009 concerning amendments to Law Number 31 of 2004 concerning fisheries, which reads as follows. First, with this law, a fishery court is established which has the authority to examine, try, and decide criminal acts in the fishery sector. Second, the fishery court, as meant in paragraph 1, is a special court within the general court. Third, fishery court, as referred to in paragraph 1, will be established at the North, Jakarta, Medan, Pontianak, Bitung, and Tual district courts. Fourth, the fishery court, as meant in paragraph 1, is domiciled at the district court. Fifth, the establishment of a fishery court is then carried out in stages according to the needs stipulated by a presidential decree. This provision regarding fisheries court is also enhanced by affirming the jurisdiction of the fisheries court by inserting one article between Article 71 and Article 72, namely Article 71A, which reads, Fishery court has the authority to examine, try, and decide criminal cases in the fishery sector that occur in the fisheries management area of the Republic of Indonesia, whether conducted by Indonesian citizens or foreign nationals. So by that, it can be concluded that every person has an equal right to sue. The best way to improving the protection for Indonesian fishermen. The Southeast Asian region has increasingly become the target and rumored to be sailing with hundreds or even thousands of tons of cargo that suddenly disappear with cargo worth hundreds of millions of US dollars. The ghost ships disappeared or were declared sinking even though they had sold their cargo and diverted to the other ship in the international waters or at other ports. These ships with certain methods of cheating, certain modes of operation change a ship's identity to a new identity or generally to countries of lack of confiance such as Panama, Liberia, Honduras, etc. Crimes related to such shipping have increased in the past 10 years. Crimes related to such shipping have increased in the past 10 years. Several types of fraud that can occur or involve crime or fraud. A number of crime cases that occur in the Natuna Sea in the past decade. Several crimes or fraud can be described as follows. First, fraudulent using the document. This activity is a crime or fraud manipulation of transport documents, arrangement, invoices, insurance posts, certificate of origin, quality certificates of goods, falsification of these letters or original letters, which are then filled with false data. Acting Director General of Maritime and Fisheries Resources Supervision or PSDKP, Nilanto Prabowo explained in the Natuna waters capture KIA often use state flags in Southeast Asia or Asia from the errors made by the ship 0 for fishing supervision post KP in the waters in the North Natuna Sea. 60% of KIA cases were found to have used fake permits or incomplete shipping document and ship permission. Okay everyone, that's all this article today. Thank you so much for watching this video. Until the next one. Bye bye.